this year under the Arizona Realtors Professional and Business Development. It's my pleasure to introduce the first speaker of the morning, Scott Drucker. Scott is the General Counsel and Assistant CEO of the Arizona Realtors. Scott's going to share updates on the recent class action lawsuits filed in Arizona targeting agents and brokers. Scott?
Perfect. Thank you, Serena. Good morning, everybody. I appreciate the invitation to come and chat. I'm at a little bit of a disadvantage here because I know you guys have met several times before, and I'm not exactly sure what topics you've covered. Rick has a tendency to cover everything and do a great job with that. I picked a topic. Hopefully, it's one that hasn't been beaten to death in here before. But even if it's something that's been discussed before, hopefully I can add some additional information and some risk reduction pointers that'll still prove helpful. As Serena mentioned, I want to talk about the Telephone Consumer Protection Act and specifically the do not call list. And I understand that the do not call list is not the most exciting topic. And to be clear, nothing has changed in regard to the law itself. What has changed is enforcement. And specifically in the last several months, we have seen a law firm that's based out of Miami, Florida. They're a plaintiff's class action law firm. They have filed 4 class action lawsuits here in Arizona against agents and brokers based on violations of the do not call list. This law firm is fairly notorious in NAR and realtor circles. As I said, they're based out of Miami, Florida. So they began by filing dozens of these do not call lawsuits in Florida. Then they set their sights on California. They filed dozens of, sorry, my camera's a little wonky there, I apologize. They filed dozens of these lawsuits against agents and brokers all across California. And now we've seen them start filing them in California. Again, we know of 4 that have been filed against agents and brokers just in the last several months. I suspect there's more that haven't been brought to our attention yet, but these are the ones that we know of so far. And understand that this law firm, they wouldn't continue to file these lawsuits and pursue this business model if it wasn't successful, right? If they weren't prevailing in the lawsuits, if they weren't securing high dollar settlements, they wouldn't continue to file the lawsuits. But the fact that they are filing the lawsuits and have now moved on to Arizona shows that it is a successful model. And so we really need to be more careful than we probably have been in the past. The problem that agents are running into is they're using these lead generation companies that are doing 2 things. The first thing is they're not scrubbing the phone numbers the way that they should be to ensure that the numbers that the agents are calling are not on the do not call list. And the second thing they're doing is they're selling auto dialer services. And these auto dialers, they can place anywhere between 80 to 300 calls an hour. And the way it works is if the recipient of the call doesn't answer, which they typically don't, it leaves a pre-recorded voicemail. And if you read these lawsuits, there's 3 auto dialer companies in particular that seem to be highlighted most frequently. The first one is called Land Voice. That seems to be the most predominant one. There's another one that's called RedX. RedX has an auto dialer feature that they call Storm Dialer. And then the last one is Mojo. And they have a service that's called Call Hammer. And again, the problem is when you don't pick up, they leave these automated voicemails and robocalls. And when I use the term robocall, all I mean is a call that plays a recorded message or that sends a mass text message. They are illegal 100% of the time unless the recipient of the call gives written permission to receive the call. And let's be honest, no one gives written permission to receive these spam calls. So generally speaking, these calls are illegal and they are violations of the do not call list. When I talk to agents about the do not call list and their use of auto dialers and buying these skip traced phone numbers from companies like Land Voice, a lot of them have an understanding that some of the calls they're placing may be in violation of the do not call list, but they still find that it is a lucrative practice, that the benefits outweigh the risks. And to an extent, I think that that's been the case, especially because government enforcement is largely non-existent, right? We don't see the government really coming out and pursuing claims against individual agents and brokerages. But where we're now seeing the issue, of course, is with these plaintiffs' class action lawsuits. And so agents will say, well, it's $500 penalty for a call. I can face that if I need to. And in worst case, it's $1,500 for a call that's a willful violation of the do not call list. And just as an aside, I would argue that proving a willful violation of the do not call list by agents may not be as difficult as it would be in other settings, because a lot of agents receive training about the do not call list, and they receive training that they need to scrub the numbers, and they're educated about it. And so when they violate the do not call list, these plaintiffs are alleging, hey, this is a willful violation. And so they're seeking $1,500 in damages. And if you take an agent that uses a, let's say a mass text message, and they're canvassing a neighborhood, and they send out 1,000 of these messages to the phone numbers that are associated with the homes in these neighborhoods. Well, if a plaintiff's class action attorney comes in and starts looking at this and gets these homeowners to sign up to be members of the class, $1,500 a pop, 1,000 text messages, you're already at $1.5 million. And so the damages can add up quickly. And all it takes for these plaintiffs' law firms to file the lawsuit is a single call. All they want to do is get their foot in the door. They find one call that's been placed by an agent. They file the lawsuit against the agent and the brokerage, and then they start subpoenaing phone records. They subpoena phone records to see what other violations have come into play. They subpoena educational materials that the brokerage has come out with. Is the brokerage recommending the use of LandVoice or RedX or any of these additional companies? If so, they're using that to tie the brokerage into the violation. Worst case scenario, they find that the brokerage doesn't recommend it, and the brokerage is doing a really good job educating the agent about not violating the do not call list. Well, that plays in their favor also, because then they're able to help establish the willful violation and seek the $1,500 per call. But they're subpoenaing all of these records to try to build the case and build the class. And so we're urging agents to not use the auto dialer services, number one. And number two, when they're buying these skip traced based leads, to scrub the phone numbers. And it's really not that hard to scrub the phone numbers. The FTC has a website, and I'm going to give you the address in case you want to write it down. It's www.telemarketing.donotcall.gov. So that's telemarketing.donotcall.gov. You get on that website, all you have to do is register. Once you register, it is free to search phone numbers up to 5 area codes. And really in Arizona, that's all you need is 5 area codes at the most. And so you can search those numbers, put them in there. There's absolutely no cost. So it's free of charge to search up to the 5 area codes. And so we're hoping that because of these class action lawsuits, and there's going to be more of them, and and they're all going to be filed by this same law firm out of Miami, Florida, that agents will start becoming a little bit more conscientious about avoiding the use of auto dialers, and then also scrubbing the phone numbers. Now, a couple of the questions I get, and probably the primary question we get from agents about this, and we recently shot a video on it, is, well, can I call for sale by owners that are on the do not call list? And as Rick and I hate to say it, but the answer is it depends. It's not a great lawyer answer, right, Rick? But it truly does depend. It depends on the nature of the call. If you're calling that for sale by owner, and because you're representing a buyer who's potentially interested in purchasing the property, you can place that call. You've been invited to place that call. But if you're calling to solicit the seller's business, right? If you're picking up the phone and calling to say, hey, why don't you go ahead and list the property with me? I can sell it faster. I can get you more money. That would be a violation of the act, because you're soliciting their business. They haven't invited you to contact them for that purpose. You're calling them to solicit their business, and that's a violation of the do not call list. And the same thing applies when you call expired listings. And if you take a look, and I've read the 4 complaints that have been filed in the federal district court here in Arizona, again, all against agents and brokerages based on violations of the do not call list. The complaints that I've read, and I've read the 4, they're based on calls to expired listings. And so that's right now seems to be the hot button issue that we want agents to be more careful about. So when you're calling the for sale by owners, you've got to make sure that you're calling for the right reason, and then avoid calling the expired listings that are on the do not call list. A couple other things that agents will say to me is, well, I can call this individual because I have an established business relationship with them. I sold them a house 5 years ago. I sold them a house 10 years ago. So I can, because of this established business relationship, I can now pick up the phone and call them and say, hey, I want you to know that your home has increased $250,000 since you bought it. Are you interested in selling it? Or calling them and saying, hey, your house has gone up. I've got a buyer who's interested in it. So can they make that call because they have that existing business relationship? And in the examples I gave you, the answer is no, because the existing business relationship applies only when the consumer has purchased, rented, leased, or utilized the services of the caller within the last 18 months. So to the extent that you had a relationship with them, a business relationship with them more than 18 months ago, you can't use the established business relationship as an end around the do not call list. The other thing that agents will say is, well, they requested that I give them information about my services, or I was at an expo and they signed a sheet giving me their name and phone number, or at an open house and they signed something giving me their name and phone number, so I can now contact them. That's true. You can contact them, but only for the period of 3 months from the time they gave you the consent. So if you're going back to a sheet of paper that they signed and agreed to 6 months ago, that doesn't work. That would again be a violation. They have to have requested information from you within the last 3 months in order for you to take advantage of that end around of the do not call list. So plaintiff's law firm coming into Arizona, they have filed these lawsuits across the country. They're setting their sights on Arizona. We really want agents and brokers to be far more careful now about violating the do not call list, because it's not just a concern that the government's going to take some sort of action, because they're not. It's not the concern that a single homeowner is going to file a $500 lawsuit, because they're not. But the concern is that this plaintiff's law firm soliciting members for this class, they're subpoenaing phone records, they're seeing who the agents have called, then they're contacting them to see if they want to be a member of the class. So be careful out there. And I'm happy to answer, Serena or Barb, if anybody has any questions. I see one on here. Does the do not call list also apply to text messages? And the answer is yes, it does. It applies equally to text messages. And part of that robocall definition for the auto dialer is not just pre-recorded messages, but it's also those mass text messages that are being sent out. So yes, that would be a violation. Next question, Greg said, what liability do the robocall companies have when they claim they scrub the numbers? They do have potential liability, but understand they're not the ones that are always placing the call. And so best case scenario is the plaintiff is suing the agent, and then potentially the agent is either naming this company as a non-party at fault, or they're suing them as a third-party defendant. But the idea is to avoid the lawsuit entirely, right? Not be in a position where you can potentially be in a long drawn-out lawsuit but blame someone else. We want to just avoid the lawsuit entirely. But yes, there is potential liability if they are misrepresenting that the numbers have been scrubbed. But my guess is, and I haven't seen the fine print of the paperwork that, when you're agreeing to purchase these services, but there may be something in there that helps to indemnify them. Anything else? Any other?
So we have another question about the maintaining contact with your sphere of influence, your past clients. And I think as long as you're contacting them on a more of a casual basis, just to check in on them, not really solicit business, is that still okay? Or
sure. I mean, if you just keep in touch with them by if you call them on their birthday to wish them a happy birthday, things like that are fine. I don't see any sort of violation in that regard. But realize that there is also a line, if you're calling under the pretense of wishing them a happy birthday, but, and you spend 30 seconds on that, and then the next 4 minutes and, 4.5 minutes of the 5-minute call are trying to get them to list with you, then you've probably crossed into a potential violation of the do not call list. But you also have to just consider, the people that you're contacting, right? If you've got a good relationship with these folks, and you're fairly confident that they're not going to sue you, they're not going to sign on to a plaintiff's class action lawsuit against you, there's obviously less risk that would be associated with that sort of call. But just as a business practice, we want to eliminate the practice.
Yeah.
How do political parties get around this? Well, the act doesn't apply to political parties. It doesn't apply to certain types of charities, religious organizations, things of that nature. So there are exceptions there, but the exceptions don't apply to real estate licensees.
So
other
politicians
than
are the exception to the rules of.
Well, they write the laws, right? So of course they're going to exempt themselves from them.
Right.
Rick, did you have something you wanted to jump in and add to this? I thought I saw you, Rick. You're muted. You're on mute, Rick. Sorry.
Is he doing the interpretive dance?
No, I was trying to push the button so you could, so I could actually talk. Good information, Scott. One thing I wanted to just add to that. Remember the department's position, guys. If you're a licensee doing cold calls, that's real estate activity. If you're calling expired listings or FSBOs, that's something you need a license to do. So hiring a third party to do it for you is a regulatory department issue as well. So if I'm a brokerage firm, I'm looking real hard about a policy saying thou shalt not hire any third parties to do this, because you got two issues now. You've got a potential class action. In addition, you have potential regulatory issues with the department.
Yeah, but one of the things you can have your unlicensed assistant do, if you don't want to do it, is you can have them scrub the numbers, right? It doesn't, it's not overly difficult to have someone log in to this FTC website, plug in the numbers and scrub them for you. That would be a good use of an unlicensed assistant, a good task for them to perform on behalf of the agent before the agent then is the one that places the call. And the good thing about when agents place the call is they're not using an auto dialer service necessarily where it leaves an automated voicemail, because that is, as I said, problematic 100% of the time unless you have written permission from the recipient of that call, and no one gives permission like that. I'll bet you we got 82 people on this call. I'll bet you there's not a single person of the 82 that's ever signed something agreeing to allow someone to spam call them by way of an auto dialer.
No, I'm pretty sure you're right on that.
Rick, Sally Lidicote was asking, where do you find that statute that you made reference to?
I don't have it committed to memory, but in the definition section, 322101, maybe 2151, there's a big laundry list of things that are licensed activity. Soliciting business by way of phone calling is one of those.
Okay, thank you.
And you can also look at the substantive policy statement, Rick, on unlicensed assistants. That references all of the statutes as well that are applicable.
Does anyone else have any other questions? I love that you just jumped in there and started reading the questions. Usually I do that for you, but
sure, no problem.
if you want to be host too, that's
it's easy enough.
Right.
All right. Well, I guess that's it for me then. So thank you guys very much.
Thank you so much. We have not had that topic, and I'm pretty sure any topic you ever bring to the table is going to be amazing anyway. So please come back. And
thanks, Serena. Take care.
You too. All right. So let's see. Next, we have Rick Mack, attorney with Manning and Cass and lead attorney over at AAR's Legal Hotline, who's going to share current legal topics he's seen in the market. Hello.
How are you?
I'm fantastic. How are you?
Good. I was talking with Barb yesterday or the day before, suggesting that I don't really have anything new to say since October 2nd, because I did one of these October 2nd for a large group as well. However, I have more, so I'm going to dive in. If those of you that were here October 2nd, the last part of this is going to be a little bit of a rehash for you, but I want to make sure we're all on the same page. The market is nuts and there's lots of moving parts. But before I get to that, let me talk to you about what has happened in the last week or so. First of all, I want to talk about licensing and reciprocity. My strong hunch is that some CE instructor in San Diego within the last couple of weeks announced that Arizona is open for business. And if you got a license in California, you can come practice here. We have had an inordinate amount of hotline calls from brokers concerned because they're, I don't want to say bullied, but they're getting aggressively harassed by California brokers saying that they can represent parties in an Arizona transaction and they don't need to go get a license because, by golly, reciprocity, and here's what happened. Literally almost a dozen of those in the last week. I assume they all come from the same seminar. Remember, reciprocity, as Governor Ducey touted it, it's got to be a year, 18 months ago now, is not really as easy as it sounds. An out-of-state broker may get some benefits in getting their license in Arizona. They may get to skip some of the CE courses. They may get to have some other sort of time-consuming tasks taken off their list. But there is no magic. I hit the button and I come in and I'm licensed. You have to take the test, pass the test, meet the other requirements that the department has established. So if you're a broker, and if you've received one of these calls saying, hey, I want to come license with you, and by the way, I've got 2 several $million-dollar deals I want to broker right now, you need to tell them, no, I cannot, I will not. You may go get your license. Once you show me you're duly licensed in Arizona, by all means, please come join me, but not until. So that's kind of been hot, and I assume it all came from the same place, and they're all based in San Diego. So I think there was some CE out there that we're now seeing the ripple effects from. The other question that is fairly hot is teams. I'm not going to spend a lot of time on this. The department finally issued a substantive policy statement on teams. What you need to remember on the team aspect is that they cannot operate as a brokerage within the brokerage. The DB has supervisory authority obligations. The money, the payments have to come from the brokerage firm. They may not come from the team leader. There may be a instruction as to how to disperse the funds from the team leader, but the money has to go to the licensee. Same with the license assistant. Little bit of just a reminder here. Who may pay a licensed assistant or an unlicensed assistant? Let's take those in turn. Licensed assistant, by definition, is probably going to be doing real estate activity. That money should come from the broker. An unlicensed assistant doing purely clerical tasks, filing, whatever, cleaning the office, whatever they do that's purely clerical, that money can come, they can be paid from the licensee. Really, the litmus test is, regardless of titles, is the work being done something that would otherwise require a license? If the answer is yes, then the compensation has to come from the broker. So that's the licensing stuff. The biggest sort of hot button I've had the last week are these California brokers saying they're entitled to be licensed here. Don't fall for it. Don't be guilted into it. That's not the way it works. They have to get their license. So any questions on the licensing stuff?
Nothing coming through so far, but you guys
Hearing
keep an eye on
none,
the chat.
I'm moving on.
Okay.
Here's one for you. When's the last time you heard anybody talk about RESPA? Forever, right? Regardless of politics, there's been a very clear shying away from RESPA enforcement in the last 3-4 years. However, there was some recent activity October 7th, so just last week, that is telling and I think fascinating. If you remember, let me give you basics. RESPA, you can't buy leads, you can't buy business, you can't pay somebody for referral. It's we all know what we're talking about. You have to be, the money exchange has to be consistent with the fair market value of the work provided. Back in 2015, there was a CFPB announcement saying that MSAs, marketing service agreements, are effectively illegal. It didn't come right out and say that. It did say they could be legal under some circumstances, but we can envision none where they would be. So it's kind of a, typical lawyer stuff. Last week, the CFPB came out with a new order withdrawing what they did in 2015. So the new order says, well, MSAs might be legal as long as there's equivalent exchange of value, the services for the money, you're okay. The timing is somewhat interesting at, a month before the election, but what they did last week was withdrew the bulletin that was in place for 5 years or so. Yeah, 5 years. Doesn't really change your practice. RESPA still applies. Just remember, you can't, there's no such thing as a free lunch is how we start the class when we're teaching RESPA. You cannot pay for referrals. It has to be a quid pro quo, reasonable value of what you're giving versus what you're getting. And I'm sure nobody saw that because I just stumbled on that the other day. I'm sure there's no questions on RESPA, so I'm moving on. That's one of the most dry topics we have.
I've got for you, Rick, if I can. So I have instances where home warranty companies will send a check to an agent for referring that home warranty company.
Whoops.
Yeah, so I just want to confirm, pretty much in any scenario, that would be a RESPA violation, correct?
Yes. And remember, RESPA applies to settlement service providers. Easy litmus test is if their service shows up in the settlement statement, they're probably a settlement service provider. Easy ones, lawyers, title, real estate agent, appraisers, home warranty companies, that sort of stuff. You cannot accept money for referring those clients. Just that's a RESPA violation. Whether you ever get caught, I guess, is the issue, but when you do, it's going to get ugly.
I have a question, Tina and Prescott. We have a new title company in town, and they are having the listing agent write in the realtor comments that if you use us, how they word it is, we've already started the escrow paperwork. If you will use us, we'll give you 50% off type thing. Are they allowed to do that? That's coming up a lot at PAR.
Yeah, and good morning. That's a different section that you're talking about, section 9 of RESPA versus section 8. The short answer is that the seller is not entitled per RESPA to select the title company. If they do demand a specific title company, then the statute says they're supposed to pay all the title and escrow, or pay the fees, title and escrow. It's one of the two, and I can't remember which. So the short answer is, if there's some legitimate work that's been done, they can certainly make that a proposal. The 50% reduction, as long as that's tough. Tammy, let's talk on offline, but that's you're pretty close to the line on that, because you're effectively providing services at a discount rate. So I question whether the services provided are commensurate with commensurate with the money paid. So it's a potential issue.
Does that answer your question?
Well, yes and no.
Yeah. Why don't you call me afterwards and give me specifics? But yeah, there's a potential RESPA violation lurking around in that. Again, because the theory is you're supposed to pay the reasonable value of the goods and services, and if you're paying less than that but getting the full benefit of the work, it's a potential problem.
Well, and their argument is, well, you don't have to use us, but
Right.
They say they've started the paperwork. Well, anybody can do that. Any title company can start paperwork for any listing.
Right.
So,
Well, and Rick, correct me if I'm wrong, but we're not allowed to require that the buyer buy title insurance from a specific title company, but the contract states that the seller is paying for the buyer's title insurance.
Title insurance, it's escrow fees is what it is. That's true.
Okay.
And the violations for the Article 9, the fines are fairly de minimis, like return of the escrow fees sort of thing. Article 9 is selecting the title company. Article 8, the violations are huge, and that's why the kickback section is what gets most of the press.
So on that topic, the vendors who are paid through escrow, like, painters and flooring companies and things like that, they sometimes offer Amazon gift cards to agents. Is that a RESPA violation?
Typically, contractors are not settlement service providers. So even though the money might be paid, I told settlement statement's kind of a big litmus test. There's some exceptions like everything. If they're not actively involved in the buy-sell process, they're not going to be settlement service providers. So generally speaking, painters, floor people, that sort of thing are not going to be covered by RESPA. So therefore a gift card is fine.
Okay. All right, you can continue.
Oh, Serena,
Or maybe not.
Serena,
We
did you
can
have-
spend hours on RESPA. There's a federal issues class where we spend most of the morning talking about it. And a lot of it's counterintuitive and doesn't make a lot of sense. But
It sounds like a really exciting
just
morning.
know that there's a new MSA, or there's a new statement on an MSA, and the feds are now saying, well, it might be possible. So another relaxing of the regulatory restrictions.
Okay. I think there was one other person. I don't
Yeah,
see who it is.
Serena, this is Barb. I see another question in here, and I wasn't sure if you asked Rick the question. It was, can you ask Rick about the question from yesterday, buyer renting a property and or listing while in escrow? prior
Yeah.
to ownership without the seller's written permission to list?
I was going to do that at the end.
Oh, later? Okay.
I figure I'd let you finish because I'm going to.
Okay, yeah, I missed yesterday, whatever that was, so.
It was a
okay,
broker
two
thing.
more things and I'll jump into, and we can talk about whatever you want, but I want to remind you of this because this was late in the day when I talked October 2nd. There's a case that just late July came out that plugged the holes created by Rose versus Young. And I want to make sure everybody knows this. Remember, Rose versus Young was the buyer's broker agreement was not enforceable because it was not delivered from the buyer's broker to the buyer. So remember, for all contracts, you need delivery. One of the issues in that case was whether the broker's initials were required to create an enforceable agreement between the buyer and the buyer broker. Case came out this year. It's a CK Family Trust case that addressed that issue. The Court of Appeals got it right. The requirement the broker's initial is a regulatory requirement. It's 322151.01G. And that's part of the 10-day review stuff. It's internal for the brokerage firm, internal for the Department of Real Estate, does not affect the enforceability between the seller and listing agent or the buyer and buyer's agent. So that gap, there's a footnote in Rose versus Young that gave us some heartburn. That gap has now been closed. So you don't need broker signatures to create an enforceable contract. You need broker signatures to make sure you're not in DRE jail. But in terms of enforceability and pursuing claims, it's not something that's required. And a footnote to that, I want to remind everybody, because I've seen this a couple times last week, the broker owns commission claims, not the agent, the broker. Agents do not have the legal authority. They call it standing. Agents do not have standing to pursue a broker claim or commission claim, be that procuring cause, buyer broker agreement in litigation, listing agreement in litigation. The brokers hold those claims. So just be careful. I'm aware of several, dealing with two right now, where rogue agents have effectively pursued claims through lawyers, and one of them in litigation, and the broker wasn't even aware and certainly didn't assign or sign off on the issue. So remember, it's your commission, not your agent's commission. All right, I'll move on.
Okay.
Just to remind everybody, there is no AAR form for a lot and a new build on it. We still get that call several times a week. I can't find it, where to go, why'd they get rid of it, blah, blah, blah. Short answer is it's not in zip forms. It doesn't exist. If you're working with a builder, make sure that the builder has a document. You don't want to draft it. You want to get either the builder's form or have a lawyer do it, but there is no current form where you can just fill in blanks for the new build stuff. And people are a little bit annoyed with that answer too, but that's the way that it's been decided for a while. So I can do any number of things now. Somebody said they had a question about a Benzer. I can deal with that. I can go back and talk about the moratorium and or the multiple offer stuff that's going on out there. You tell me what you want next.
Well, I will say we had a conversation with a bunch of brokers yesterday, and we were talking about equitable interest. So when someone is purchasing a property to list it as a rental, they have equitable interest to be able to get that renter in place, but can they advertise that rental prior to actually owning the property?
So yeah, short answer is as long as, let me just address it specifically.
Okay.
It's going to depend to some degree on your MLS rules. So make sure you look at that. But generally speaking, an equitable interest is a property interest. And I can tell you that the Metro Phoenix MLS, I don't like to be called armless anymore, does allow that. My impression is most MLSs throughout the state do allow that. You don't hold fee title, you hold equitable title, which means you've got a contract to close at some point in time. So you can list. The question is going to be, can you deliver possession? And that's no, you cannot deliver possession to a tenant or a subsequent buyer until you've actually closed and gained possession yourself.
So I know there's a couple of MLS experts in here, so maybe they can help clarify. I know I was looking through the rules yesterday and it says that the listing is with the owner. And I think that's where part of the confusion is the owner, the equitable owner or the owner?
It's right. And to some degree, you're going to have to look at the ER and how they define, is owner a defined term in the ER? And if it is, does it say the fee title owner of the property? So I think that's going to be to some degree jurisdiction specific based on the ER adopted.
Okay, interesting. Okay, Liz, I don't know if you're able to unmute, but would that answer the question? Do you have anything to add to that, Ms. Harris? I don't know where she's at, but okay. I had a question that I would love to ask you and Scott. I don't know if Scott is still here. I don't know if he left or not. About Benzers and requesting handyman or sorry, licensed professionals and that sort of thing. I know I've had this conversation with you and Scott separately, but I would love to hear the both of you come together and not say things like it depends.
Well, but we're lawyers. Everything depends, right? And think of it this way. I can get 2 hotline calls from 2 brokers on either side of the transaction and get told one story and give them answer A, and get told the same story with a little bit different twist and give them answer B. So it is very fact specific. If you think about all the millions of cases filed in the legal system throughout the country, in the history of our country, that's always been 2 lawyers disagreeing about something and disagreeing enough to put on their guns and go fight the fight. So it is going to be factually specific. So tell me again, the Benzer process, and is the question, can you demand licensed contractors?
Well, and I guess the question is, can you request a licensed contractor and is that enforceable? Like if the seller says, no, we're not going to use licensed contractor, and then they just accept that they're going to do the repairs without responding, that was the question I had asked you a couple years ago.
There's about 4 layers, and I'll just start at the top. Because and Martha Apple disagrees with me. There's some brokers that disagree with me. I think Scott is on the same page to a large degree, but we can ask him. But let me just start at the beginning.
Okay.
The work needs to be done per the contract in a workmanlike manner. We can all agree on that. That's what the form says. The other thing we can agree on is if the work is more than $1,000, by definition, by law, by statute, a licensed contractor has to do that work. It's $1,000 permit required and or substantial improvement is what they call it. So if it's something more significant than cleaning out the gutters or something that would typically require a license, roofing, HVAC, plumbing, gas, those sort of things, and it's more than $1,000, regardless of what the Benzer says, a licensed contractor is required by law to do it. People don't like that, but that's the answer. And let me give you the pushback or the rationale from a broker point of view of why that's good. You're not spending the money. The broker's not spending the money. The seller is. If you recommend that a handyman repair an electrical sub panel and then the house burns down and come to find out you needed a license for that work, you've got problems. You've got really significant problems as a broker. Flip that and you refer a licensed contractor. The licensed contractor does the work and the house still burns down. It's unfortunate, but you're not going to have any exposure on that. So the licensed contractor, as a matter of risk reduction, is better for the brokerage firm. It might cost a few more bucks to the seller, but you know what? Licensed contractors have been tested and vetted and approved by the state. You're not referring what I like to call your drunk brother-in-law to do a bunch of work. So reasonable workmanlike manner, over $1,000, you must do it. Now we can get down in the weeds, and here's where people diverge quite a bit. The question I often get is, can the buyer request that work be done by a licensed contractor? Yeah. Why can't they? They can request it. The seller can say no, but the buyer can request it. Some people disagree with that and say the buyer can't even request. But there's nothing in the contract, there's nothing in Arizona law that says a buyer cannot request something. They're in contract negotiations. A buyer can request a $50,000 price reduction. They can request prepossession. They can request all sorts of stuff. Someone doesn't have to agree, but the buyer can request it. So my take is, even though arguably for minor repairs, the seller doesn't agree in the contract to hire a licensed contractor, the buyer can request it in the Benzer. So the buyer can request. So now let's see where we go from there. Buyer requests it. Seller signs the Benzer, telling everybody that's looking at the document that the seller's agreed to do the work by way of a licensed contractor. Then the seller says, no, I didn't really mean that. I'm not going to have a licensed contractor. Is that a problem? And people disagree with me on this as well. Yeah, you got a contract. You've amended, whether you want to call the Benzer an amendment or not, you've changed the contract terms. There's an offer from the buyer that says, I want this work to be done by a licensed contractor. And there's an acceptance by the seller signing it moving forward. So if the seller signs, then the seller has agreed that a licensed contractor would do the work. That's above and beyond what the contract says, but they agreed to it. So be it, they've got to do it. I think we're okay there. At least it all makes common sense to me here. The next layer down is where it gets more difficult. So let's say there is a plumbing issue that costs $500. And it's a plumbing issue in the ceiling. The buyer's justifiably concerned that they don't want some drunk up there that's not licensed doing the work. And they say, I want a licensed contractor to do it. There's a good faith request. Seller says, no, I'm not going to. I'll do the work, but it's going to be my drunk brother-in-law doing it, not a licensed contractor. So then what happens? Can the buyer cancel? The buyer's asked for something, the seller said no. Is that a valid Benzer? So here's where the disagreement comes, and tell me if I'm kind of getting close to the issue you want to talk about. Mm-hmm. My take is the buyer made a request. Seller said no. The buyer then gets the 5 days to either say okay or cancel. That's my position. I think that's what the law and the contract provide for. There are other people that say by requesting a licensed contractor, you've somehow presented an ineffective Benzer, and therefore the seller saying no, the buyer doesn't have any further options. The buyer can't cancel. The buyer can't, all the buyer can do is move forward. So I think that's the issue you're driving at, which, how far, I think that's as far as we go down in weeds. Anybody else have anything else that spins off from that?
Well, we do have a couple people that probably agree with this, that the Benzer is not technically an addendum to the contract, it's a notice. So I guess that's part of the question is, does it actually change the terms of the contract if it is just a notice?
Well, let's talk about that. Okay. Because people get caught up in the labels, and it's post contract execution. It's a written document where the buyer is asking the seller to change terms, right? The contract says present physical condition. That's the way the buyer agreed.
Very valid. By
way of the Benzer, the seller is requesting that buyer's requesting the seller do something. That's a change in terms. It's not just a notice, it's a change in terms. Just by providing the notice up front, yeah. But once the seller agrees to it, you've got a written document signed by both parties, presumably delivered, that changes terms. I don't care what label you put on that, that's an addendum. It's a change in the contract. Even if you want to get away from an addendum, it's a written change in the contract terms. So it's not just the notice once the buyers and sellers sign off on it.
I love that perspective. I hadn't thought about it like that. And as far as excessive of $1,000 or cumulative amount of $1,000, it's per type of repair, correct? If it's
typically it's per trade, that's right. Yeah. So if you have 4 repairs that are $250 each, completely different trades, you're probably going to be okay.
Okay, awesome. Let's see, we have Yeah, Michelle's article pretty much says it's not an addendum. I like the perspective though. I think it is an agreement between the parties
Again,
to change
when you
terms.
first
And
provide it, it's a notice. When
Yeah.
the buyer provides it, it's a notice. When the seller accepts it, you're changing terms. I don't care what you call it, you're changing terms. So you have a writing changing the terms signed by everybody and delivered. You got an additional page to your contract. I don't care what you call it. You've got an additional page to the contract.
I love that you were here to discuss that. I wish Scott was here because I've had a different conversation.
I think
with
Scott and I are on
He
board with that.
escaped.
He sides a little bit with you can't. I think where he and I diverged a year or so ago, and I think he's got it right. He agrees with me. Is that you can't request a licensed contractor? I think you can request it. Seller doesn't have to. Seller agreed only to make repairs in a workmanlike manner. The parties are further negotiating what a workmanlike manner looks like.
Right.
And I have a spin-off of that if we're done. People hate this topic, so I'm happy to talk about it as much as you want. But what I always default back to is a licensed contractor benefits the broker. So why on earth is there the bias to push handyman on people? I don't get that. It makes no common sense to me.
Oh yeah, no,
So-
I'm sure we all push licensed contractors.
Yeah.
So I'm sure we all do as brokers.
I
So
did
what
a
about
hot-
negotiating price on the Benzer? We've had that question
we-
come up.
Yeah.
Somebody wants to put credits on the Benzer. How does that play out? Tell us about that.
Okay. There might be some changes coming on the Benzer, by the way, but it's not going to be anytime soon. Let me give you both sides of that. This is like a pop quiz, man. You're asking me stuff I didn't even get ready for.
Weren't we playing Stump the Lawyer?
Yeah, that's it. Stump the lawyer. So I might be wrong. I don't know, but the Benzer stuff I think I'm right on, and I think that's the way a judge would look at it. This one, credit on a Benzer. If you submit a Benzer on behalf of a buyer that simply says, in lieu of repairs identified in the attached home inspection report, seller to credit buyer $5,000. Is that a valid Benzer?
Yep.
No.
I know this one.
And what happens if the seller says, nope, not going to do it? The inspection is waived. You've gone through your inspection period. You've made a request. You did make a request that you should have, and therefore there's no more buyer inspection. Buyer's either going to have to close escrow or lose the earnest money or potentially be sued. So if you just ask for money, bad policy, don't do it. You're putting your buyer at risk. What if you say, and here's the common practice, seller to fix ABCD, alternatively, seller to credit buyer $5,000, see attached addendum. So number one, you've made a valid Benzer. You've requested repairs, which is, remember, the Benzer is supposed to address items not approved by the buyer.
Mhm.
So you say, okay, ABCD are not approved, therefore seller fix them. If you don't want to, then give me a $5,000 credit. That is acceptable. That is the way most people do it. But let me take you one step further, because there's layers upon layers upon layers to this. How are we going to deal with this $5,000 credit? Is it a $5,000 reduction in purchase price? Is it a $5,000 credit against closing costs? And assuming that's the case, what if there are not enough closing costs to cover the $5,000? So then you've got this credit kind of floating out there that the buyer maybe never really gets the benefit of. So you got to be careful with that. The other issue, and this one gives me heartburn, is there's the code of silence out there. Well, don't tell my lender. Don't tell my lender. They won't fund the loan. If the lender knows about this, they're not going to fund. What's that sound like?
Nothing
Sounds to
good.
me like we're hiding material fact to make somebody behave in a way that we want them to. I.e., I don't tell them there's a $5,000 roof repair that needs to be made. Lender's not aware. They fund the loan. And are we all somewhat privy to a mortgage fraud obligation or scheme there? The not telling the lender, it's been happening for a decade, and I cringe every time I hear it. And it's practice. It's common practice, what people do. But if the underwriter of the loan, not the loan broker who's going to make their $7,000 commission, who has an incentive to go up through, providing notice to the loan broker, that's not really notice to lender. if the underwriter, if the person looking at the loan package is not aware, and if the underwriter would not approve funding at that level or at all, if they were aware, that's a problem. And people do it all day, every day.
Yes, I agree. So if a buyer submits a request with just money on it, should the seller be required to cure them for a valid BINSR?
I think we put that in the contract. I know we discussed it. I haven't looked at that issue. Sometimes I have to get the form out, but yeah, I think the seller, out of fairness, and most of this is about fairness. We're realtors. We're trying to close a deal. We're not trying to take advantage and have sharp elbows. Yeah, the seller should cure. I think the revisions we did in 17, I don't have it right in front of me, but I think they have the option to cure. But I'd have to look. They still got to do it timely. They still got to get it in within 5 days. Wait till the end of the 5th day, you're gonna have some problems.
Yeah, this is Tina again in Prescott. I called you on this exact same thing. And it must be an option in the contract because they were trying not to cure
Right.
us and didn't. Trying to be sneaky and just, make it go for full price without any repairs and all that kind of stuff. So
Right.
it's definitely an option at this point.
You know what? I'm doing hotline letters right now, so I'm gonna address that one.
Yes.
Cure bad
Thank you.
BINSR.
Yes.
Well, and what happened was she sent out the addendum with it and they didn't sign the addendum either because they're not required to. So luckily, remember, we didn't turn in the earnest deposit yet. So we got away with it, but that could have really gone badly for us.
Yeah.
Thanks. On the follow-up on the equitable interest.
Yeah.
So are they allowed to market the property without the seller having any knowledge of it? Or do they need seller permission to market that property based on their equitable interest?
It's going to be MLS specific, certainly, assuming they have the ability to market it under the MLS ER, the specific one. We have 17 associations. It's going to be specific to that, assuming they have permission. Assuming they are able by way of the ER. The best practice is that the seller give permission. However, I am not aware of any legal requirement that the seller actually give permission. Clearly, they're going to have to give permission to give access. But in terms of just putting it in the MLS or otherwise marketing, my take is I'm aware of nothing that would legally require the, buyer independent escrow get permission from the seller to list the property or market the property for sale or rent.
Because they're marketing their equitable interest.
Yeah, they're marketing what they have. Again, best practice, full disclosure and transparency. It would be best if you did to avoid the drama, but I'm not aware of a legal requirement that would make you do that.
I think if everybody was doing best practices, we wouldn't be here talking to you. So,
Yeah, the hotline wouldn't be ringing 400 times
you'd
a
have a
month.
really
I
boring
have
job.
another one, actually, before we move on and talk
Go
about
for
best
it.
practice, because I can't say this enough. Multiple offers, they're coming fast and furious. What I want to remind you, buyers agents that don't get their offer accepted are not happy. Buyers are not happy. People get an emotional attachment to houses. There's a line in the contract where the seller can initial and reject. It's 473, I think it's there towards the end. Reject offers in writing and get those delivered back to the buyer's agent. I know it's a pain. I know people don't want to do it, but in this market, when there are sometimes dozens of offers and then dozens of unhappy buyers and lots of buyer's agents who are suspicious that their offer was not presented, then that can give rise to a DRE complaint, a realtor ethics complaint, or just a bunch of drama. Easy best practice is to have your sellers, if they're lucky enough to have multiple offers, have them spend the extra 10 minutes it's going to take to initial and date 11 rejected offers. And then you, listing agent, get that out to the buyer's agent. So the buyer's agent knows the seller's looked at it, the seller's rejected it, and here's proof. And it calms a lot of the distrust, because we're getting a lot of angry buyer's agents calling the hotline saying, this no good SOB didn't even present my offer.
Yeah, I agree. I think a lot of us would love to see that. Plus, we have to keep those rejected offers as well.
We got to keep them anyway, right?
Let's see.
The code was amended.
Yeah, can you expand on that?
Can you hear me?
Yeah.
Yeah, in January of 2019, Article 1-7, the Code of Ethics was amended such that when a buyer agent asks in writing for proof that their offer was submitted, the listing agent is now required in writing to respond to that request.
But in writing, that would include an email as well, right? So it's not
Yeah.
necessarily
Yeah.
forcing them to sign that, which
Yeah,
Right,
that
and again,
practice.
by doing it, by habitually having a practice of submitting those rejected offers to a buyer's agent, you're avoiding the Article 1 violations, the ethics complaints, and also the DRE complaints.
Right.
Appearance of impropriety, I mean, as well.
Yeah.
Say you present, you know.
Well, there's
present-
also listing agents obligated by law to present all offers. So,
Yeah.
if they don't present one, and when it even gets worse is when, just coincidentally, the listing agent is a dual agent on the one that got accepted. That's what gets people really kind of riled up. But any way you look at it, it's a good practice. Encourage your agents to have their sellers initial that rejection box and give to the buyer's agent. Make it part of your standard practice.
Agreed. Does anyone else have anything for Rick before we let him go and we go into our breakout rooms? You have something, you can go ahead and unmute, or you can type it in the chat.
I would like to address the equitable interest for a minute.
Okay.
Okay, RMLS does allow a listing of equitable interest. It's always been required that it's been disclosed in the MLS, and within the past couple of years or so, it's in the special listing conditions. It's a drop-down menu, whether or not it's an equitable interest listing or not. And I know Code of Ethics, Articles 4 and 5 address interest in a property, and in the advertising rules and ADRE, whether or not you have an interest in a property must be disclosed in all advertisements. Wholesalers, for example, put homeowners out under contract. They don't have any closing whatsoever. They just want to advertise their equitable interest. That must be in all advertising, whether it's MLS or not. Just want to add on to that.
Yeah, and I agree 100%. In your marketing materials, that the equitable interest piece of it must be disclosed. I agree. And if I give you the impression, the question posed to me was, do you have to tell the seller
Right.
that you're listing the house for rent to a potential third party? And that one's a little bit iffy. But no, in terms of the advertising and the marketing you do, you have to tell them what you hold. Remember, we talked about the bundle of sticks you had. They don't have all the sticks. They just got some of the sticks. You got to identify what interest it is that you are marketing for sale or lease.
Agreed on the seller issue. Yeah.
Yeah. All right. Well, with that, thank